I held the eviction notice in my hands, hiding my smile, while my son-in-law's girlfriend eyed my custom-made furniture. "Pack up your junk and get the hell out!" he screamed. Foaming at the mouth, I calmly nodded and left. The next day, they returned to an empty building. The bank accounts were drained too. They fell into hysterics. Before continuing, subscribe to our new channel, as this one will soon be closing. You will find a link to the new channel in the description of this video, in the pinned comment, or you can simply click on the subscribe button and select the second channel. My name is Raymond Arthur Fletcher. I am 68 years old, and I live in a modest bungalow in the Selwood Moreland neighborhood of Portland, Oregon. For most of my working life, I ran a small architectural firm called Fletcher Design Group. I retired 3 years ago, but I kept everything that mattered: the property, the contracts, and the habits of a man who thinks in structures. I see problems the way I used to see blueprints. Find the load-bearing walls first, everything else follows. I should explain the building before I explain the betrayal. 2847 Northwest Thurman Street is a 2-story commercial property I purchased back when this part of Portland still had reasonable real estate prices and optimistic landlords. 4,200 square feet. Ground floor for business operations, second floor for storage, and my personal workshop, where I build furniture by hand when I need to remind myself that some things still respond predictably to effort. It is not a glamorous building. It is solid, well-maintained, and it belongs to me outright. I have the deed to prove it. 2 years ago, my daughter Claire died. She was 41 years old, and the illness that took her was neither fair nor slow. I will not spend much time on that, because grief is private, and this story is about something else. What matters here is that Claire had been married to a man named Courtney Wayne Simpson, my son-in-law, who was 41 himself and ran a small consulting business that had always depended more on charm than on billing hours. After Claire passed, I made a decision that felt generous at the time and foolish in retrospect. I offered Courtney use of the ground floor at 2847 NW Thurman. We formalized it with a proper lease, $1 per year, a 5-year term, and a partnership agreement that made me a silent partner in his business, with 51% participation and signature rights on the shared account. I also put $87,000 of my own money into renovations, custom oak countertops, built-in shelving I made myself, and a conference room paneled in black walnut that took me 3 weekends to install. I wanted Courtney to succeed. He was Claire's husband, and helping him felt like honoring her. For about a year, the arrangement worked reasonably well. Courtney ran his operation, I checked on my workshop upstairs occasionally, and we stayed out of each other's way with the comfortable distance of 2 people who share grief but not much else. Then, roughly 8 months ago, Tamara Dean Cole appeared. I first noticed Tamara the way you notice a change in weather, not dramatically but unmistakably. Courtney began arriving at the building later. The conference room started smelling like a different kind of coffee, the expensive decorative kind that comes in small cups and accomplishes very little. Personal items appeared on the shelves I'd built. A handbag here, a jacket there, a collection of small decorative objects that had no business being in a commercial office. Tamara was 34, precise about her appearance, and possessed of the particular confidence that comes from having always used beauty as a primary business strategy. She looked at every surface in that building the way a buyer looks at a house she has already decided to make an offer on. I said nothing for several months, because I am not a man who speaks before he has something worth saying. I watched, I noted. I made entries in the journal I have kept for 3 years, recording every significant conversation and observation with dates and details. An old habit from project management. You document as you go, because memory is not a legal instrument. The situation clarified itself on a Tuesday morning in February. I came to the building to check on a woodworking project I had left upstairs, a set of drawer joints I wanted to inspect before finishing. I came through the front entrance, as I always do, because the building is mine and I have never needed to announce myself. The ground floor was occupied by Tamara, alone. She was moving slowly through the space with her phone held out in front of her, photographing the custom shelving the conference room panels, the reception counter. She did not hear me come in, and for a moment I simply watched her catalog my work with the focused efficiency of someone running an inventory. She startled when she saw me, recovered quickly, gave me a smile that was approximately 40% warmth and 60% calculation, and said she was just getting some ideas. Ideas for what? She did not specify. I nodded, said nothing, and started toward the stairs. That was when Courtney came through the back hallway, moving fast, his face carrying the particular redness of a man who had been building toward something and had decided this was the moment. He had a sheet of paper in his hand. He held it out to me and said, loudly enough for Tamara to hear clearly, that he was giving me formal notice, that the old man needed to clear out, that this was his space now, and he was done pretending otherwise. The words came with volume and with the clumsy confidence of someone who had rehearsed them, probably with an audience of one, probably the night before. I took the paper and read it. It was a single page, printed in a large font, with the words Notice of Eviction centered at the top. It referenced no statute. It cited no lease terms. It contained no legally operative language of any kind. It was, to be precise, a man's angry feelings, formatted to look like a document. I stood there reading it while Courtney continued talking, and I felt something that I can only describe as a very quiet satisfaction, the kind that comes when a long prediction turns out to be exactly correct. I folded the paper carefully, put it in my jacket pocket, and looked at Courtney for a moment without speaking. His volume decreased slightly in the silence, the way a speaker does when the audience stops reacting. Then I nodded once, turned around, and walked back out through the front door. I crossed the parking lot, reached my car, and stood beside it for a moment, in the cold February air. Then I took out my phone. I did not call anyone standing in that parking lot. I simply looked at the phone for a moment, opened my contacts, and confirmed that the number I needed was still there. Eric Powell, attorney, 1033 Southwest Broadway, Suite 500. I had saved his number 18 months earlier, after a conversation at a Portland Chamber of Commerce event, where he spoke clearly and without the performative modesty that makes some lawyers exhausting to listen to. I had thought at the time, I may need this man eventually. I have learned to trust that kind of thought. I drove to his office directly. The drive along Burnside gave me about 12 minutes to think, and I used them the way I use most unstructured time, by going back through the sequence of events and looking for the places where I might have misread something. I found very few. The truth was that I had seen this coming for roughly 4 months, since the day Tamara photographed the conference room for the first time, and I watched Courtney pretend not to notice her doing it. I thought about the afternoon 3 years ago when I sat across from Courtney at the kitchen table of Claire's house, just 2 weeks after the funeral, and we talked about the building. He had been quiet that day, genuinely so, not performing grief, but carrying it the way a tired person carries something heavy, without making a production of it. He told me he wanted to build something real. He said he did not need charity, just a fair start. I believed him. I believed him because Claire had chosen him, and I had trusted Claire's judgment in most things. The partnership agreement had been her idea, actually. She mentioned it months before she died, when she could still have calm conversations about practical matters. She said, "Dad, if something happens to me, look after him a little. He is not as capable as he thinks he is, but he is not a bad person." I had written that down too, not in the journal, but somewhere that mattered more. By the time I reached Powell's office and spread my 3 documents across his conference table, I had finished grieving the version of the situation where Courtney was simply lost without Claire. That version had expired somewhere on Burnside around the 15th Avenue intersection. Powell studied the documents for 11 minutes without speaking, which I appreciated. When he looked up, he had the contained expression of a man who has just confirmed a diagnosis he already suspected. He said, "They sent you an eviction notice for your own property, under a lease that charges $1 per year and gives you termination rights for material breach." He paused. "Either this is a joke, or they genuinely did not read what they signed." I said, "They read it. They just assumed I would not." Powell nodded slowly. "That is a more expensive assumption than they realize." We discussed the immediate steps. The lease contained a specific clause allowing early termination by the owner upon documented material breach of use conditions. The partnership agreement governed by Oregon revised statutes. Chapter 67 gave me, as the majority silent partner, the right to act unilaterally to protect partnership assets when there was documented evidence of misuse. The deed was clean, unencumbered, and entirely in my name. I had, as Powell put it, a complete set of tools and a very clear problem to solve. I asked him about a private investigator, and he gave me the name Dennis Hart without hesitation. Hart had an office on NE Oregon Street and a reputation for thorough documentation without unnecessary drama. I called him from Powell's conference room and described what I needed: a record of how Tamara and Courtney were actually using the space, personal storage, non-business activities, any indication of plans to repurpose the property for retail use. Hart said he could begin the following morning. I appreciated that he did not ask many questions. The second call I made that afternoon was to my niece Adeline Fletcher Morrow, my brother's daughter, who has worked as a certified public accountant in Portland for nearly 15 years. She is 44, careful, and constitutionally incapable of softening bad news, which makes her the most useful person I know. I asked her to examine the transaction history on the shared partnership account for the past 3 months and tell me what she found. She called back in just under an hour. Her voice had the particular flatness it acquires when she is reporting something that makes her professionally angry. $23,450 had been withdrawn over the past 90 days for purposes with no connection to the business: restaurant charges, furniture store purchases, 2 round-trip flights, and a series of transfers she described as having the coherence of someone spending money they do not believe will ever be audited. I sat with that number for a moment. Then I thought about the black walnut panels in the conference room, the oak countertops, the built-in shelving. $87,000 of my own work and money, provided in good faith, while $23,000 of partnership funds were being used to furnish someone else's ambitions. I called Powell back and asked him a single question: how long do I need to make this clean and irreversible? There was a short pause on the line. Then he said, "If your documents are in order, 48 hours." I looked out the window at Southwest Broadway, at the gray February sky over downtown Portland, at the ordinary Tuesday afternoon moving past without knowing it was about to become the before in someone's story. I said, "The documents are in order. They have been in order for 3 years. I have spent most of my professional life working from plans. Not instincts, not impulses, but actual plans, drawn carefully, reviewed twice, and executed in sequence. When you design a building, you do not start with the decorative elements and hope the foundation appears beneath them. You start with what holds everything up. Then you build toward what people will eventually see." That Wednesday morning I began building. Powell's office called at 8:45 to confirm that the formal legal notice was being prepared. Under Oregon Revised Statutes, Section 91.090, a commercial property owner can terminate a lease for material breach with 30 days written notice. The documented violations were specific and supported. Dennis Hart had spent 2 days outside 2847 NW Thurman Street with a camera and a straightforward brief, and the results were more than adequate. Photographs of Tamara's personal wardrobe hanging on the built-in shelving I had constructed by hand. Images of furniture catalogs spread across the oak conference table with handwritten measurements in the margins, measurements of my conference room, written by a woman pricing out her future boutique in someone else's building. Hart had also spoken briefly with a neighboring business owner on Thurman Street, who had seen Tamara greeting what appeared to be retail vendors at the side entrance on 2 separate occasions. Not a business meeting, a scouting session. I looked at those photographs for a long moment over my morning coffee at home before driving anywhere. There was something clarifying about seeing documented what I had previously only observed informally. Tamara had not been careless. She had been confident, which is a different thing and considerably more useful as evidence, because confident people do not bother concealing what they are certain they will keep. Powell submitted the legal notice by courier that morning. 30 days. clean, formal, legally operative. The kind of document that contains actual statutes and means what it says, unlike the piece of paper Courtney had handed me 2 days earlier. I did not wait. The lease termination was the visible layer of the project, the exterior wall. But a building is not just its walls, and I had no intention of standing outside for 30 days, watching Courtney and Tamara use a space I owned for purposes I had not agreed to. As the silent partner holding 51% of the partnership and maintaining full signature authority on the shared account, I had documented grounds for protective action under Oregon partnership law. I had Adeline's accounting summary, Hart's photographs, and Powell's written analysis. The bank does not require a judge's permission when a majority partner presents evidence of financial misuse and formally requests protective measures on the account. I drove to the Wells Fargo branch on Southwest Broadway that morning and sat across from a business banking officer named Marcus, who was approximately 30 years old, professionally courteous, and visibly accustomed to people who arrived with incomplete paperwork. I arrived with a folder that contained everything he would need and several things he had not thought to ask for. The partnership agreement, Adeline's transaction analysis, Powell's letter, my identification, and deed. Marcus looked through the materials twice, excused himself for 8 minutes, and returned to tell me that a new operational account would be opened in the partnership's name under my sole signature authority, and that the existing account access for the secondary party would be suspended pending review of the submitted documentation. The existing account balance would remain protected and untouched. Courtney's portion of personally contributed funds, $4,230, would remain available to him once the review process concluded. I thanked Marcus, collected my folder, and drove back toward Thurman Street. Not to go inside. I drove past slowly, the way you do a final inspection of a project site before the client takes possession. The building looked the same from the outside as it always had. Solid, well-maintained. Mine. From there I went to meet Karen Reed, the commercial real estate agent I had contacted through a referral from the Chamber of Commerce. Karen was 52, direct, and had the particular energy of someone who finds genuine pleasure in matching properties to tenants. She had already identified 3 serious candidates for the ground floor space: an architectural firm called Cascade Design Partners, a mid-sized legal practice looking to expand its Portland presence, and a specialty coffee operation wanting a premium location. The going rate for comparable commercial square footage on Northwest Thurman was $8,500 per month. Karen said all 3 candidates were motivated. I told her to keep all 3 conversations warm. I would have a clear timeline within 48 hours. The moving company arrived at 2 o'clock that afternoon. I had scheduled them 2 days earlier, immediately after my conversation with Powell, because I had learned a long time ago that waiting to schedule the practical steps is how projects stall. 6 men, 2 trucks, and a specific inventory list I had prepared at home the previous evening. Every piece of furniture in that building that I had made, purchased, or installed was on that list with location notes. The custom oak reception counter, the built-in shelving in the main office, the black walnut conference room panels, the secondary workbench upstairs in my workshop space. All of it documented, all of it mine, all of it going into climate-controlled storage on Northeast Columbia Boulevard until I decided what came next. Courtney had left his own laptop in the center desk drawer, his personal coffee mug, and a small framed photograph. I instructed the crew to leave those items exactly where they were. I am not a man who takes things that do not belong to me. That has always been the distinction between us, and I saw no reason to blur it now. By 6:15 that evening, the crew was done. I walked through the ground floor once before locking up. The space was clean, empty, and larger than it looked furnished. The walls held the marks of where shelving had been mounted, small rectangular patches slightly darker than the surrounding paint, evidence of something that had been there and was no longer. I found that I did not mind the look of it. I drove home to Selwood, made dinner, and sat in the chair by the window with my phone on the side table. The 30-day notice had been delivered. The account had been restructured. The building had been cleared. Everything was in sequence, Everything was documented, and there was nothing left to do tonight except let the next 12 hours arrive on their own schedule. My phone stayed quiet. I knew it would not stay quiet long. Courtney was a man who reacted quickly and thought slowly, which is a difficult combination in any situation, and a particularly poor one when the person across from you has been thinking carefully for several months. Tomorrow morning he would arrive at 2847 NW Thurman Street and open the door. I picked up the biography on the side table and read until the light outside had gone completely dark. I did not go to Thurman Street the next morning. I never seriously considered going. A man does not stand in the rubble of someone else's miscalculation and wait to be thanked for the structural analysis. Instead, I drove to Courier Coffee on Northwest 4th Avenue, ordered a black coffee, took a corner table away from the window, and opened my copy of a Frank Lloyd Wright biography I had been working through for the past 2 weeks. Wright was a difficult man with an extraordinary ability to impose his vision on spaces that had not asked for it. I found him instructive. Dennis Hart called at 9:41. He did not say much. He rarely did. What he told me was this. At 9:14 that morning, Courtney's black SUV had pulled into the small lot beside the building, followed by Tamara's gray sedan. They had arrived together, which suggested the previous evening had involved planning. Courtney used his key on the front door, which still worked because I had not changed the locks, and had no legal right to do so before the 30-day period concluded. The locks were still his to use. The building was still mine to empty. Hart described what the camera had captured in precise and efficient language. Courtney entered first, stopped in the main office doorway, and stood still for what Hart estimated was close to 15 seconds. That is a long time to stand still in a doorway. Then Tamara came in behind him and immediately moved toward the conference room, the way a person moves toward the thing they have been thinking about most. The conference room where the black walnut panels had been, where the custom table had stood, where she had spread her furniture catalogs and written her measurements in the margins. The room was empty, 4 walls and a window. Hart said her reaction was visible even on a small monitor from across the street. I turned a page in my book while he talked. Wright had just demolished a client relationship by refusing to install adequate kitchen storage. The client had wanted somewhere to put dishes. Wright had wanted visual coherence. I have some sympathy for both positions. Courtney, according to Hart, moved to the desk area next and opened the drawer where his laptop had been left. It was still there. His coffee mug was still there. The small framed photograph was still there. Everything that belonged to him remained exactly where he had placed it. Everything that had ever belonged to me was gone. I thought that was a reasonably clear communication and required no accompanying note. Then he checked his phone. Hart could not see the screen, but he could see Courtney's face, and the expression that crossed it was apparently the kind that takes a moment to fully arrive, like weather moving in from the coast. He sat down in the chair at the now empty desk, in a room stripped of every surface I had built or paid for, and stared at the banking application on his phone. $4,230. His contribution, protected, untouched. The rest of the account, the portion representing partnership operations, and the funds Adeline had traced across restaurant receipts and furniture invoices and 2 round-trip flights, was no longer accessible to him. The bank's review process had its own timeline, and that timeline did not include his convenience. Hart said Courtney called my number 7 times in approximately 12 minutes. I watched my phone register each call from across the table at Courier Coffee and let everyone go to voicemail. I was not avoiding the conversation. I was timing it, which is a different thing entirely. A conversation that happens at the moment of maximum panic rarely produces anything useful. Courtney needed a few minutes to move from disbelief into the particular cold focus that comes after disbelief, when a person finally accepts what they are actually looking at. Tamara's reaction, Hart told me, was less contained. She moved through the building twice, checking rooms I had not furnished and surfaces I had not touched, as if the missing items might have relocated rather than departed. At one point, she stood in the center of the main office and said something with considerable volume and limited precision. Hart did not report the specific words, and I did not ask. Whatever she said, she was performing for an audience of one, and Courtney looked, by Hart's description, like a man who had just begun to understand that the person who designed this situation was not him. I finished my coffee, ordered a second, read about Wright's falling water project and the engineering problems that nearly compromised the cantilever. Solutions exist for bad engineering, but they cost more than building it correctly the first time. I have always thought that was a lesson with wide application. On the 8th call I picked up, I did not say hello. I did not ask how he was doing or comment on the weather. I simply waited, because I already knew what I was going to hear, and I wanted him to use whatever words he had chosen. The line was open for about 3 seconds before Courtney's voice came through, and the volume of it was not entirely suited to a quiet coffee shop, so I held the phone a few inches from my ear. He said I had no right. He said I had stolen from him. He said what I had done was illegal, that he would have me in court before the week was out, that I had no idea what I was dealing with. He said several other things that were variations on those themes, with diminishing coherence as the sentence length increased. Tamara's voice was audible behind his, providing what I would describe as editorial commentary. I waited until the volume dropped slightly, the way a storm does before it decides whether to continue. Then I spoke in the same tone I use when I am explaining load calculations to a contractor who has questioned my math. I told him that I held signature authority on that account, that I held 51% of the partnership under a signed agreement governed by Oregon law, that my name was on the deed to that building and had been for 22 years, and that every item removed from the premises was my documented property. I told him that the bank had not made an error. I told him that the 30-day notice was legal, specific, and already delivered, and then I told him the number that I wanted him to carry with him for the next 4 weeks. You have 27 days, Courtney. There was silence on the line, not the silence of someone thinking, the silence of someone who has just located the load-bearing wall and realized it is not where they assumed. I set the phone face down on the table, picked up the biography, and found my page. The letter from Brett Carr arrived on a Thursday, 4 days after Courtney stood in that empty building trying to understand how gravity works. Powell's office received it first, as I had instructed, and Powell called me at home that afternoon with a tone of voice that fell somewhere between professional concern and quiet amusement. Carr and Associates, he said. Brett Carr. He does commercial litigation, mostly landlord-tenant disputes on the tenant side. He is aggressive, he is expensive, and he is very good at making noise that sounds like substance. I asked Powell to read me the key demands. The letter ran 4 pages. Carr wanted the partnership account access restored within 5 business days. He wanted the removed furnishings and fixtures returned to 2847 N.W. Thurman Street or replaced at fair market value. He characterized my actions as a unilateral breach of the partnership agreement, a wrongful exercise of majority authority, and an intentional interference with Courtney's business operations. He used the phrase irreparable harm twice and bad faith 3 times. He closed with a paragraph suggesting that failure to comply would result in an emergency motion for injunctive relief before the Multnomah County Circuit Court. I listened to all of it without interrupting. When Powell finished, I said, "How much of that is supportable under ORS Chapter 67? Powell's pause was brief, the part where he spelled your name correctly. I told him to draft a formal response and prepare the supporting documentation packet we had assembled over the previous weeks, Hart's photographs, Adeline's transaction analysis, the partnership agreement with the relevant clauses highlighted, the bank's written confirmation that the protective measure had been applied, pursuant to submitted documentation. Powell said he would have it ready by Monday. I told him that was fine, and that I was not worried about Brett Carr. I was not. A letter written to frighten someone into a quick settlement is a letter written for a person who frightens easily. I have sat across from building inspectors, city planning committees, and contractors who believed their interpretation of a project was the only valid one. Pressure is a tool. It only works if the structure it is applied to has weak points. What concerned me was not Carr. It was the thing Carr represented. which was Courtney thinking clearly enough to retain professional help within 72 hours of discovering an empty building. That was faster than I had expected. Either Tamara had a contact, or Courtney was more organized under pressure than I had given him credit for. I filed that observation and kept moving. The next development came not from Courtney's direction, but from Tamara's, and it was more creative than I had anticipated, from someone whose primary documented skill set appeared to involve furniture catalogs and Instagram. Adeline called me on Saturday morning, and she was not using her calm, accounting voice. "She came to my office," Adeline said. "Tamara Cole. She called the day before, said she was a potential client and wanted to discuss some financial planning. I should have checked, but the name did not connect. She sat down across from me, asked about 3 minutes of entirely generic questions, and then said she was concerned about you, about your memory. She said you had been making decisions lately that seemed, and I am quoting her directly, Uncle Raymond," she said, confused, like someone who does not fully understand what he is signing. I sat with that for a moment. There is a particular kind of move that relies on the assumption that the person being described is isolated, that no one who knows them will compare notes quickly enough to matter. Tamara had looked at me and seen a 68-year-old man living alone in a Selwood bungalow, and she had concluded that the efficient way to neutralize me was to question whether I was entirely present. It was not a bad calculation if the facts had been different. The facts were not different. They were extremely, thoroughly documented. I told Adeline to write down everything she remembered from that conversation, every phrase, every sequence, with as much specific language as she could reconstruct. "I already started," she said. That is the thing about Adeline. She does not wait to be asked twice. Powell had that written account by Monday afternoon and turned it into a formal affidavit within 48 hours. Adeline signed it. It went into the documentation file alongside everything else, another floor added to a building that was already standing on solid ground. The bank's decision came through on Wednesday of that same week. Wells Fargo confirmed in writing that the protective measure applied to the shared account was consistent with the documentation provided, that the request fell within the rights of a majority partner under the terms of the agreement, and that the initial complaint filed by Carr's office had been reviewed and did not meet the threshold for reversing the protective hold. $4,230 remained available and ring-fenced for Courtney. Everything else remained frozen pending resolution of the partnership dispute. I read that letter twice at my kitchen table with a cup of coffee and the specific quiet satisfaction of watching something you built hold weight the way you designed it to. Then I filed it. 2 days later, at 7:48 in the morning, my phone showed a message from Dennis Hart, 3 photographs attached. The first showed Courtney standing on the sidewalk in front of 2847 Northwest Thurman Street, hands in his pockets, looking at the building's exterior. The second showed him in conversation with a man I did not recognize, mid-40s, carrying a leather folder of the type that real estate professionals favor at property viewings. The third was a closer frame. The man had turned slightly, and the leather folder was open. Inside it, partially visible, was what appeared to be a property data sheet with a photograph of my building at the top. I set my phone down on the kitchen table and looked out the window at the backyard where the bare branches of the oak tree were just beginning to show the first suggestion of new growth. Courtney was not just fighting the eviction. He was planning something with a realtor. The question was what kind of plan required a property data sheet for a building he did not own and could not sell. I called Hart back within 10 minutes and asked him to find out who the man with the leather folder was. Hart said he already had a name. The man's name was Glenn Purcell, a licensed commercial real estate broker operating out of an office on Northwest 23rd Avenue. Hart had run the license number from Purcell's vehicle and confirmed the registration that morning before sending me the photographs. I thanked him and then sat very still for about 30 seconds, which is what I do when I need to let a new piece of information settle into the correct position in the overall picture before I respond to it. Then I called Powell. Powell listened to the description of the photographs and the name Glenn Purcell, and was quiet for a moment before he said, "Right of first refusal." I asked him to explain exactly what Courtney was attempting. Powell laid it out in the measured, precise way that I had come to appreciate about him. Courtney, through Carr, was apparently preparing to assert that a verbal agreement had existed between the two of us, a conversation in which I had allegedly promised to offer Courtney the opportunity to purchase the building at half of its appraised market value before selling or leasing it to any outside party. No written record of this agreement existed because, according to the theory Carr was constructing, it had been a private, informal understanding between family members who trusted each other. The realtor was there to establish what Courtney would claim was his legitimate due diligence on a property he believed he had been promised. If Courtney could persuade a judge that such an oral agreement existed, he could potentially file for an injunction blocking my lease with any new tenant until the matter was resolved in court. That process could take months. Karen Reed's 3 interested parties would not wait months. I told Powell I needed to think, and I drove to Adeline's apartment on Southeast Hawthorne Boulevard. We sat at her kitchen table with 3 years of financial documents spread between us and 2 cups of coffee going cold at the edges. Adeline is the kind of person who organizes documents chronologically without being asked, which means that within 20 minutes we had a complete, sequential record of every transaction, every payment, and every deposit connected to the partnership and the building lease from the date of signing forward. The rental agreement specified $1 per year, annual payment due on the anniversary of the signing date. I had the signed contract. I had 3 anniversary dates that had passed. And across 3 years of banking records, there was not a single incoming transfer, not a check, not a cash deposit, not any transaction of any amount from Courtney Simpson to Raymond Fletcher in connection with rent. Not $1, not once, not ever. I pointed to the column where those payments should have appeared and looked at Adeline. She nodded slowly. He never paid you, not even symbolically. Powell's reaction when I called him from the parking lot outside Adeline's building was calm in the way that a person is calm when they have just been handed something useful. He explained that under Oregon law, an oral agreement regarding real property is generally unenforceable without written documentation, but that a creative attorney could still use it to create delay and uncertainty. However, a party asserting a verbal promise of preferential treatment while simultaneously having failed to meet even the minimal written obligations of an existing formal agreement was going to have a difficult time presenting themselves to a judge as someone acting in good faith. Courtney had not paid $1 in 3 years. He had signed a lease that said $1 per year. He had spent $23,450 of partnership funds on personal expenses, and now he was standing in front of my building with a realtor, claiming I had made him a private promise. I thought about Brett Carr building that argument in a courtroom and trying to keep a straight face. I drove directly from Adeline's apartment to Karen Reed's office on Southwest Morrison Street. Karen was at her desk with coffee in her laptop, and she looked up with the attentive expression of someone who has learned to read urgency in the way a client walks through the door. I told her I wanted to move immediately on Cascade Design Partners. She blinked once. You said you wanted to wait until the legal situation was resolved. The legal situation, I said, will resolve itself faster if there is a signed lease already in place. Karen understood. She was on the phone with Cascade's representative within 5 minutes, and by that afternoon we had a confirmed agreement in principle. The formal lease documents were drawn up over the following 2 days, $8,500 per month, occupancy beginning the 1st of May. Karen handled it with the efficiency of someone who knows that motivated parties and clear terms produce signed agreements, and motivated parties were exactly what we had. The lease was executed and filed before Carr had submitted anything to the court. I was at home in Selwood that evening when Powell called. His voice had shifted slightly from its usual measured register, not alarmed, but sharpened. Carr filed this afternoon, he said. Multnomah County Circuit Court. Breach of oral agreement and wrongful exclusion of a business partner from partnership assets. I asked Powell if he had read the filing. I have. It is ambitious. I would describe it as optimistic in a way that suggests someone is billing by the hour. I looked out the back window at the oak tree in the fading light. "Good," I said. "Then we will answer it properly." Carr had filed his lawsuit against a man who had just signed a lease with a new tenant, held a counter-documented case for $23,450 in misappropriated funds, possessed an affidavit describing an attempt to undermine his legal competency, and had 3 years of bank records showing that the person now claiming the protection of an oral promise had never honored the written one. Optimistic was one word for Carr's position. The lawsuit landed on a Tuesday, and I will admit that for about 45 minutes that evening I sat in my Selwood bungalow and did the math on what a prolonged court fight would cost me. Powell had given me a realistic range. If Carr pushed hard and the case dragged into full discovery, I was looking at $40,000 in legal fees, minimum, before a judgment ever came down, possibly more. Carr knew that arithmetic as well as I did, and he was counting on me to feel it the same way his client felt it. The problem with that calculation was that it left out one variable. It left out the notebook. 3 years ago, when I first sat down with Courtney and explained the terms of the arrangement, something in the back of my mind, the part that spent 4 decades watching projects go sideways when verbal agreements were treated as binding, that part suggested I keep records, not recordings. I am not the kind of person who records conversations secretly. I am the kind of person who writes things down, immediately, while the words are still precise in my memory. Date, time, location, who was present, what was said, in what sequence, and what was agreed. I had 47 pages of those notes, 3 years of meetings, phone calls, discussions about the building, discussions about the business, discussions about the partnership structure. Every significant exchange between me and Courtney, documented within 24 hours of when it occurred, written by hand in the same green-covered journal I used for my birdwatching notes when I ran out of space in that volume. I pulled the journal from the fireproof box in my hall closet and drove it to Powell's office the morning after the filing. Powell read it at his desk while I drank his coffee and looked out at Southwest Broadway through the 5th-floor window. He turned pages slowly and carefully, the way a person reads something that is getting better as it goes. After about 20 minutes, he stopped on a specific page and read it twice. Then he looked up. "March 14th, 2 years before all of this," he said. "You have a notation that Courtney explicitly declined any purchase option." "He did?" I said. "We were sitting in the 2nd-floor office. He said the words, and I wrote them down that same evening. His exact phrasing was that he did not need to own the building, he only needed the space to run the business. That ownership was a burden he did not want." Powell set the journal flat on the desk. "And Adeline was present?" "She had come by to drop off some documents. She walked in during that specific part of the conversation. She heard it." Powell was quiet for a moment. When he spoke again, his voice had the particular quality it takes on when he is already organizing the sequence of arguments in his head. "Carr is building his entire case on an alleged oral promise that you would sell him the building at a preferential price. Your journal contains a contemporaneous written record made within hours of the conversation stating that Courtney himself declined any purchase option and described ownership as a burden. There is a corroborating witness who was physically present, and this was written down 2 years before any dispute arose, which means there is no credible argument that you fabricated it in response to litigation." I finished my coffee. "That would be my reading as well." We spent the next 2 hours with Powell outlining the counterclaim in detail, the misappropriated $23,450 from the partnership account, the documented lease violations supported by Dennis Hart's photographs and log, the affidavit from Adeline describing Tamara's visit to her office and the attempt to suggest I lacked mental clarity, the journal entry directly contradicting the central premise of Carr's lawsuit, the 3 years of unpaid rent, even at the symbolic $1 annual amount the lease specified. It was, as Powell described it, with a rare trace of satisfaction, a thorough counterclaim. That afternoon I got a message from Hart. He had been running a background check on Tamara Cole as part of the ongoing documentation work, looking for anything that established a pattern of behavior. What he found was a civil judgment filed in King County, Washington. A previous landlord in Seattle had pursued Tamara for $11,200 in unpaid rent and property damages, and the judgment had been entered against her. The debt remained unpaid. I sat with that for a moment. Tamara had come into a building I had spent $87,000 renovating, had walked through the rooms calculating what things were worth, had pushed Courtney toward a confrontation he was not prepared for, and had been doing all of it while carrying an unpaid $11,000 judgment from her last attempt at establishing herself in someone else's space. She was not a person who had bad luck with landlords. She was a person who had a method. I wrote that observation in the journal, not because I needed to, but because I have always found that writing something down helps me understand exactly what it is. 2 days before the first hearing, my phone rang at 7 in the morning. The number was Courtney's. He did not start with an accusation. That was the first sign that something had shifted. He started with a question. He asked if I would be willing to meet somewhere, just the two of us to talk. He used the phrase, talk like adults. He said he thought there might be a way to resolve this without the court having to decide everything. He said he would come to me, wherever I wanted. I told him courier coffee the following morning at 8. Then I hung up and sat for a moment, looking at the kitchen window, where a Stellar's jay was working through the seeds I had left on the sill. Courtney Simpson was calling me without his lawyer, without Tamara, and offering to come to my neighborhood at 8 in the morning to have a conversation he had framed as something adult and reasonable. 3 weeks ago he had handed me a piece of paper in a building I owned and shouted at me in front of a woman who was already calculating the square footage. I noted the time of the call, the exact wording of his request, and the absence of any mention of Tamara in my journal. Then I made another cup of coffee and went to the backyard to watch the birds. He was already there when I arrived, which surprised me. Courtney has always been the kind of person who arrives precisely on time to demonstrate that his time is equally valuable as yours, or a few minutes late to suggest it is more so. Sitting at a sidewalk table at 7:54 in the morning, hands wrapped around a paper cup, watching the door, was not his register. He looked like a man who had not slept well in several days. The jacket was a good one, because Courtney does not own bad jackets, but it was not pressed the way he usually keeps things. There were shadows under his eyes that no amount of careful grooming was covering. He had arrived early, alone, in the kind of condition that tells you more than whatever words are coming. I ordered my coffee at the counter, carried it out, and sat down across from him without rushing. He started with her name, not Tamara's. My daughter's. He said her name carefully, with the specific weight a person uses when they are deploying something they believe still has power. He talked about what we had been through together, the 2 years of her illness, the end of it, the silence after. He said he had always felt that the arrangement with the building was a form of family continuity, a way of keeping something of her alive in the daily work. He looked at me steadily while he said it, checking whether it was landing the way he intended. I drank my coffee and listened without responding. When that approach did not produce the reaction he needed, he shifted. He leaned forward slightly, elbows on the table, and told me what he actually wanted. He wanted me to restore his access to the partnership account, specifically to the $4,230 that remained in it. He wanted a 60-day window to formally wind down the business operations and remove his personal belongings. He said that if I agreed to those terms, he would instruct Carr to withdraw the lawsuit. Clean end, he said. Everyone walks away. He used the word reasonable 3 times in 90 seconds. I looked at him for a long moment. He held the eye contact, which told me he had rehearsed this and still believed it could work. Courtney, I said, you signed a partnership agreement. The agreement specifies in plain language that documented misuse of partnership funds constitutes grounds for dissolution and forfeiture of partner access. You spent $23,450 of shared operating funds on restaurant bills and personal furniture. That is documented by the bank. I filed those records with the court. I did not change the rules. You agreed to them in writing, and then you ignored them. He opened his mouth. I am not finished, I said. You did not violate the agreement accidentally. You did it over a period of 3 months. in consistent increments, while simultaneously having someone visit my niece's office to suggest I was confused about what I was signing. That is not a family disagreement. That is a documented pattern. So the reason this conversation is not going to produce what you came here for is that I have already given the judge everything I am telling you right now, and it is significantly more persuasive coming from bank records than it is coming from a sidewalk table. Courtney was quiet for a moment, then his expression shifted in the way that happens when a prepared approach has failed and the person reaches for whatever is underneath it. He said he had known my daughter in ways I had not. He said there were things about her character that people who loved her did not always want to examine. He left the implications sitting there between us, shaped like a threat. I buttoned the middle button of my jacket and stood up. "You can say whatever you want about her," I said. "She is not here to respond, and I am not going to respond on her behalf to a man sitting at a coffee table in an unpressed jacket 3 days before a court hearing. My documents are already with the judge. Whatever you say next happens in that context." I picked up my cup, nodded once, and walked to my car. I drove back to Selwood and sat in the kitchen for 20 minutes, not thinking about Courtney, thinking about my daughter, quietly and on my own terms, the way I prefer. At 11:47 the following morning, Hart sent me a single message. No photographs this time. Just text. It read, "Tamara Cole departed Portland International Airport this morning on a flight to Seattle. 1 bag checked. No return ticket on record." I read it twice, then set my phone face down on the workbench in the garage, where I had been measuring boards for the new bookcase. I picked up the pencil and marked the next cut line. The wood was straight-grained white oak, the same species I had used for the countertops in the building on Northwest Thurman Street, though those were someone else's concern now. Tamara had done her arithmetic. The judgment from Seattle was in the record. The lawsuit was 3 days from its first hearing. Courtney had gone to meet me alone, which meant she already knew the position was not recoverable from where she was standing. People who move through spaces calculating what things are worth develop a very clear sense of when the numbers have stopped working in their favor. Courtney had come to that table hoping to negotiate. Tamara had apparently decided that Seattle was a better option than a Multnomah County courtroom. He had handed me a piece of paper in my own building and called me unnecessary. Now he was sitting somewhere in Portland without a lawyer present, without Tamara, without access to the account, and with 3 days until a judge read 47 pages of notes I'd been keeping since the month he moved in. I finished marking the boards, set down the pencil, and went inside to make lunch. The Multnomah County Circuit Court building on Southwest 4th Avenue is not a dramatic place. It is a government building with fluorescent lighting and hard benches, and the particular smell of recycled air and old carpet that all government buildings share regardless of what happens inside them. I have always found that gap between the plainness of the setting and the weight of what gets decided there to be quietly interesting. The most consequential moments in people's financial lives tend to happen in rooms that look like waiting areas for something else. Powell and I arrived 40 minutes early. That is his habit, and I have adopted it without complaint. We sat in the hallway outside the courtroom, and he walked me through the sequence one final time. Not because I needed it, but because preparation is how Powell manages the hours before a hearing. He is thorough in the way that people are thorough when they have seen what happens to cases that were not. Carr arrived 12 minutes later with Courtney behind him. Courtney was dressed impeccably, which I expected. The jacket was pressed, the shoes were polished, and he had arranged his face into an expression of calm confidence that I recognized as the same expression he wore on golf courses and at the kind of restaurants where the menu does not list prices. He did not look at me directly when he came through the door, which told me more than the expression did. Carr, I had been told by Powell, was effective in certain kinds of cases. Personal injury, some contract disputes. Commercial real estate and partnership law in Oregon were not his strongest territory, and Powell had noted this without any particular satisfaction, the way a builder notes that a competing structure used the wrong grade of material. The hearing began. Carr stood and presented his client's position with considerable energy. He described a relationship built on trust and family obligation, painted Raymond Fletcher as a man who had made promises, and characterized the removal of assets and the freezing of the account as a unilateral betrayal of an understanding that had existed for 3 years. He used the word family 4 times in his opening. He used the word promise 7 times. He used the phrase oral agreement of good faith twice, which is a phrase that sounds meaningful until someone asks what it means legally in the state of Oregon. The judge, a woman in her early 60s with reading glasses on a chain and the expression of someone who has heard most things at least once, let Carr finish without interrupting. Then she asked her question. She asked it the way a person asks something when they already know the answer is going to be unsatisfying. Counsel, your client is asserting the existence of a purchase option agreement. Where is the written record of that agreement? Carr explained that the agreement had been verbal, made in the context of a family relationship and a long-standing arrangement of trust. The judge looked at him over the reading glasses. Oregon does not recognize oral agreements for the transfer or option to purchase real property, she said. That is not a nuance of the law. That is the law. What written evidence supports your client's position that such an agreement existed? Carr pivoted. He spoke about the spirit of the relationship, the expectations that had reasonably developed over 3 years of operation, the equitable principles that should inform the court's reading of the circumstances. The judge made a note. She did not appear moved by the equitable principles. Powell presented our response with the efficiency of someone who has organized his materials well and does not need to perform urgency because the documents do the work. He introduced the journal, 47 pages, handwritten, dated entries spanning 3 years, each one made within 24 hours of the conversations they described. He drew the judge's attention to the entry from 14 months before the dispute began, in which Courtney Simpson, in his own words as recorded by the other party present, had explicitly declined any purchase option and described property ownership as a burden he did not want. He introduced the affidavit from Adeline, who had been present at that conversation, and confirmed its content under oath. He introduced the banking records showing $23,450 drawn from the partnership account for purposes having no relationship to business operations. He introduced Hart's documentation of lease violations. He introduced the 3 years of 0 payments, not even the $1 annually that the signed lease required. Carr objected to the journal as self-serving documentation. Powell noted that self-serving documentation made contemporaneously over a 3-year period, before any dispute arose and corroborated by a witness affidavit, was precisely the kind of evidence courts relied upon when no other written record existed, which was, as Carr himself had just acknowledged, the situation his client had created by conducting his affairs verbally. The judge sustained Powell's position. She dismissed Courtney's lawsuit. She used the word insufficient twice, and the phrase no cognizable legal basis once. She accepted our counterclaim regarding the misappropriated partnership funds as a separate matter to be scheduled for its own proceeding. Courtney sat very still while she spoke. The expression of calm confidence had not exactly collapsed. It had simply become a different kind of stillness, the kind that happens when a person is absorbing information they were not prepared to receive. His hands were flat on the table in front of him. He did not look at Carr, and Carr did not look at him. I watched the judge's face while she spoke, because I find that more instructive than watching the people the ruling is directed at. She was not satisfied or dissatisfied. She was simply clear. That kind of clarity is its own form of satisfaction, I think. In the hallway afterward, Powell stood beside me with his briefcase and summarized what had just happened in 2 sentences, which is another habit of his I appreciate. Then he said, Carr reached out to me 20 minutes before we went in. He wants to discuss settlement on the counterclaim. Courtney is prepared to return the $23,450 over 90 days and sign a full release of all claims against the building and the business. I told Powell I wanted 1 night before I responded to anything. He nodded. He understood that the arithmetic on a settlement versus a second proceeding was not the only calculation involved. I drove back to Selwood. It was mid-afternoon, and the light on the Willamette was the particular flat gold that shows up in early spring when the clouds are thin rather than heavy. I sat in the kitchen with the back door open for 20 minutes before my phone rang. It was Adeline. Her voice had the specific precision it takes on when she has found something that changes a number she thought was final. She had gone back through the partnership account records one more time that afternoon. There was a transfer she and I had both looked at in the initial review and categorized as ambiguous because the payee name was not immediately identifiable. She had traced it. $6,800, transferred to an account registered in Tamara Cole's name, 7 days before Courtney handed me that piece of paper in my own building and told me to leave. 7 days before the eviction notice. The money had moved before the confrontation. That meant it had not been a reaction to the conflict. It had been part of the preparation for it. I thanked Adeline. I wrote the amount and the timing in the journal. Then I sat for a while looking at the entry, because this is what I had built over 3 years without knowing exactly how I was building it. A complete record of exactly what had happened and in what order, by people who had assumed that a quiet older man keeping notes in a green-covered journal was not going to matter. I called Powell the next morning at 8 and told him we were not accepting Carr's terms. Powell was quiet for exactly the kind of pause that means he is already thinking about how to structure what comes next, not whether to do it. I told him about the $6,800. I told him about the timing. He asked me to send him Adeline's documentation before noon, which I did. By 3 that afternoon, Powell had sent Carr a revised settlement proposal. The terms were not complex. Courtney would return $30,250, the original $23,450, plus the $6,800 transferred to Tamara's account from shared partnership funds. He would return that amount within 60 days, not 90. He would sign a full legal release of every claim, present and future, related to the building at 2847 Northwest Thurman Street, the partnership account, and the business that had operated out of that address. He would agree in writing not to enter the property or contact its future tenants. Carr called Powell the following morning. The call lasted 11 minutes. When Powell relayed the outcome to me, his voice had the same quality it had in the courtroom when the judge sustained our position, steady and accurate. Courtney had agreed to every condition. I was not surprised. The alternative was a second court proceeding, with the same 47 pages of notes, the same banking records, and now an additional transaction that had been made 7 days before his confrontation with me, from shared funds to the personal account of the woman who had walked through my building, taking photographs of the furniture. A jury instruction on that sequence of events would not require much elaboration. Courtney signed the settlement documents on a Thursday morning. Powell handled the exchange without requiring my presence, which I appreciated. I had no interest in being in that room. I had no performance to give. The documents were the conclusion of a project, and I do not attend the close-out inspection of every project I complete. The 1st of May arrived on a clear morning with the kind of Portland sky that only appears for about 6 weeks each year, high and sharp and genuinely blue, rather than the gray that passes for sky the rest of the time. I drove to Northwest Thurman Street and parked across from the building. Cascade Design Partners arrived at 9 in the morning in 2 moving trucks. They were a small architectural firm, 7 people, and they had the particular organized energy of a group that has planned a move carefully and is executing it without drama. I watched them carry in drafting tables and flat-file cabinets, and the kind of ergonomic chairs that cost more than most people would spend on a sofa. They were efficient. They knew where everything was going. The building looked the same from the outside. The brick had not changed. The windows were the same proportion, but the inside was becoming something else now, which is what buildings do when they are used for their purpose, rather than treated as something to be held and leveraged. I stayed for about 30 minutes. Then I drove home. My oak countertops were in the garage workshop, stacked against the south wall where the light comes in strongest. The custom shelving panels were stored flat beneath the workbench. I had not decided yet exactly what I would build from the materials. I was thinking about a bookcase for the hall, something with integrated cabinet space at the base, proportioned for the specific wall where it would stand. The white oak boards I had been cutting before the hearing were already dimensioned and ready. There is a particular satisfaction in starting a project that is entirely your own, with materials you selected and cut yourself, for a space you know by memory. No partners, no agreements, no shared accounts, just the wood and the work. Adeline arrived that afternoon with a pot of minestrone and a bottle of sparkling lemonade, because she is the kind of person who marks things with food rather than words, which I have always found to be the more intelligent approach. We sat on the back porch of the Selwood bungalow in the afternoon sun. The Steller's jay that had claimed the seed tray as personal property was working through the sunflower seeds with his usual lack of interest in our presence. Adeline ate her soup and did not feel the need to deliver a speech about what had happened, and I did not deliver one either. The first payment from Cascade Design Partners arrived the following week, $8,500 on time, by electronic transfer with a reference line that said, monthly rent, Northwest Thurman, and nothing more. It was, without question, the most satisfying rent payment I had ever received, including every payment from every tenant across 22 years of owning that building. 8 weeks after the settlement signing, Courtney's payment arrived, the full $30,250, transferred in a single transaction. No note, no accompanying message, just the number and the confirmation. I showed Adeline the notification on my phone. She looked at it, nodded, and poured more lemonade. Hart had sent me a final update 2 weeks after the court date. Tamara Cole had not returned to Portland. She had no filed address in Oregon. The unpaid judgment from Seattle remained unpaid. Whatever arithmetic she had done when she booked that one-way ticket had apparently produced a result that kept her in Washington. Courtney had moved to Eugene. I knew this because the settlement required him to provide a forwarding address for correspondence related to the dissolution of the partnership. He had given a Eugene address, and I had noted it in the journal, and then closed the journal on that page and not reopened it. That summer I finished the bookcase. It took 11 weeks, which is longer than I originally planned, because I added cabinet doors at the base with hand-fitted mortise and tenon joinery, the kind of construction that takes more time but does not require anything to hold it together that was not already in the wood. It stood in the hall now, exactly where I had measured for it, proportioned correctly for the space. In the last week of summer, I opened the green-covered journal to a fresh page and wrote one sentence. Project complete. Structure holds. Then I closed it, set it on the shelf beside the biographies, and went back to the workshop to start measuring for the next piece. If you like this story, subscribe to our new channel and listen to several stories there. You will find the link to it in the collaboration or description of this video or in the comments. Subscribe so you don't lose track of us, because this channel will soon cease to exist.